Welcome to the Deep Dive. We take apart complex professional rules and ideas and try to make them really clear and usable.
That's the goal.
And today, we're tackling something absolutely critical. It's about the legal and ethical tightrope that regulated professionals walk, specifically when they're supervising other people's work.
It's a huge area of responsibility.
We're digging into what professional accountability really means, especially for engineers and geoscientists here in Canada. The big question, the one with real teeth, is what does it actually mean to take responsibility for work done, under your direction?
Yeah, and that phrase, under your direction, carries so much weight. It's really the foundation. Professionals are given this trust, right?
Yeah.
To protect the public, the environment, and the integrity of the profession itself.
And that trust isn't just for the work you do with your own two hands.
Absolutely not. It extends completely to everything you oversee, everything you supervise. There's no dividing it up.
Okay, that distinction is key. And just before we dive deeper into the legal principles here, if you're finding this discussion helpful, maybe for understanding professional standards or preparing for the NPPE exam.
Which this is highly relevant for.
Exactly. Please take a moment and subscribe. You'll get more of these deep dives designed to help you get ready and succeed on the NPPE.
Okay, so let's unpack that core duty.
Right. Let's look straight at the laws, the Engineering and Geoscience Acts. They state very clearly professionals must take professional responsibility for any engineering or geoscience work performed by themselves or under their supervision. It sounds simple, but wow, legally.
Oh, it's packed. That short sentence lays out two really non-negotiable points. First, you can delegate tasks. That's management. You can assign work to your team.
Sure, standard practice.
But you absolutely cannot delegate the accountability, the final legal and professional responsibility for that work. It stays with you, the supervising professional. You're the one who has to answer for it.
No pass in the buck.
None. And second, the law demands that your supervision has to be active and informed. It's not just signing off or being vaguely aware.
So not just checking boxes.
Definitely not. It means real oversight, checking that standards are met, making sure the work is technically sound, safe, fit for purpose. If you weren't actively involved in ensuring that, then legally you weren't supervising.
And for you listening, it's worth remembering why this duty exists. It's not just bureaucracy.
No, it's entirely about protecting the public interest.
It ensures that complex projects, things that affect lives and the environment, are ultimately guided and guaranteed by a qualified professional who takes ownership.
Precisely. It prevents things falling through the cracks when multiple people are involved.
Okay, but let's talk reality. Office life, project deadlines. The sources draw a really sharp line between supervision in this legal sense and just being a manager. How different are they really? If I'm a busy project manager, how do I realistically provide that active oversight?
That's a common point of confusion, but it's a vital distinction in a regulated field. Being a manager involves budgets, schedules, resources. Supervision, in this context, is purely about technical control and professional judgment.
Gotcha. Technical control.
Exactly. And to make that supervision valid, to satisfy the code of ethics and the law, there are essentially three core things you have to do.
Okay, what are?
First, you need direct involvement. This means you have to actually understand the project, the scope, the technical risks, the details of the work being done under you.
So you need the competence yourself.
Yes. You can't adequately supervise, say, a complex structural design if your expertise is solely in electrical systems. You need enough knowledge to meaningfully review and assess the work.
Makes sense. What's second?
Second is continuous interaction. This isn't a one-off check at the very end. It means regular communication, scheduled reviews, talking through issues with the person you're supervising.
Keeping the dialogue open.
Right. Being accessible, having substantive technical discussions, not just asking, are you done yet? It helps catch errors early, clarifies intent. It's crucial.
And the third?
The third is professional review and approval. This is the final jade. The supervising professional must personally review and authorize the final work, the final document, before it goes out the door, before it goes to a client or a regulator or the public.
That's the moment you officially take responsibility.
That's precisely it. It signifies your due diligence is complete and you stand behind it.
You mentioned something earlier, or rather the sources do, about proportionality. That seems really practical. You wouldn't supervise a new grad the same way you'd oversee a senior technologist with 20 years experience, right?
Absolutely right. The level, the intensity of supervision needs to be proportional. It depends on two things: the complexity and risk of the task itself, and the demonstrated competence and experience of the person doing it.
Can you give an example?
Sure. Let's say you assign a really complex analysis, maybe using new software or a novel approach, to a junior engineer, someone just starting out.
Okay.
Proportional supervision there might mean daily check-ins, reviewing their input data step by step, maybe even independently verifying all their key calculations before relying on them. Very hands-on.
And the flip side, a senior technologist doing a routine inspection they've done hundreds of times.
Well, the supervision is still required. It must be active, but it might look different. It could involve reviewing their procedure up front, maybe doing periodic technical spot checks on their findings, discussing any unusual results they flagged.
But still reviewing.
Still reviewing, and crucially, ensuring they're working within their own defined scope of practice and competence. The supervising professional, the PING, or PGO, is always the ultimate backstop, ensuring the overall work meets the standard. You don't just assume competence.
Okay, so all these duty, the involvement, interaction, review, proportionality, it all kind of funnels towards one really significant action.
Yeah.
Applying the professional seal. And this is where I think the rubber really hits the road, legally and ethically. That seal isn't just decoration.
Not at all. It's arguably the most potent symbol in professional practice. It transforms a report or drawing from just information into a formal, legally recognized professional document, something clients, regulators, and the public rely on.
So what exactly is the professional declaring when they stamp that seal on a document?
They're making, effectively, three simultaneous, very serious declarations. First, they're stating the work complies with all the relevant laws, codes, standards, bylaws, all the official rules. It's compliant.
Check.
Second, they're declaring the work was done competently and ethically, that it meets the standards expected of the profession.
Okay, competence and ethics.
And third, and this ties directly back to supervision, they are declaring that they accept full personal responsibility for the content of that document and for the potential outcomes or consequences of relying on it.
Full personal responsibility.
Personal. It's not the company's responsibility at that point, it's yours. It's your professional guarantee standing behind that work.
Which makes sealing work done by others a really critical point.
Yeah.
What if, say, a manager holds a PING license and they seal a design done by someone on their team, maybe another PING, but the manager didn't actually do the technical review because they were busy managing?
That's exactly the scenario these rules are designed to prevent. It's a major violation. The sources are crystal clear. You can only seal work prepared by someone else if you have exercised proper active supervision.
Meaning you did the direct involvement, continuous interaction, and review we talked about.
Precisely. You have to have verified its technical soundness, checked it yourself, ensured it meets all safety and regulatory requirements. Only then can you seal it.
And if you don't, if you seal it without that rigorous review,
that act, sealing without sufficient review or supervision, is explicitly defined as professional misconduct.
Wow. Not just a mistake, but misconduct.
Correct. It's a serious breach of professional integrity, a failure of your duty to the public. It doesn't matter if an accident happens later or not. The act of sealing unreviewed work is, in itself, misconduct and can lead straight to disciplinary action.
Let's talk more about those consequences then. The stakes are clearly high. When supervised work does go wrong or doesn't meet standards, what happens? You mentioned the professional is exposed.
Yes, the exposure is multi-layered. First, there's the disciplinary track through the professional association. If negligence or non-compliance is found due to inadequate supervision,
The association steps in.
they will. They'll investigate, hold hearings, and if misconduct is proven, the sanctions can range from, say, a formal reprimand or mandatory training to significant fines, suspension of your license, or even, in very serious cases, complete revocation. Losing your right to practice.
Okay, that's the professional body. What about outside that?
Then you have civil liability. This is where lawsuits happen. If someone suffers damages, financial loss, property damage, injury, even death because of negligent work you supervised.
They can sue you personally.
They can sue you, yes. And potentially your company. But the supervising professional is often named directly. The claim would be based on professional negligence failing to meet the expected standard of care in your supervision.
And how do they prove that negligence in a supervision context? Is it just if the subordinate made a mistake?
Not necessarily just the mistake itself, though that's the trigger. Proving negligence usually focuses on the supervisory process. Did you fail to implement reasonable checks? Is there no record of your review?
The documentation again.
Exactly. If there's no evidence, no review comments, no checklists, no meeting notes showing technical discussion, it becomes very hard to defend against a claim that you failed to exercise due diligence. That lack of process is the negligence, which can make you liable for the damages caused by the error.
That's a heavy burden. Is there anything beyond disciplinary action and civil suits?
In the most extreme cases, yes. There's the potential for criminal charges. This is rare, thankfully, but it can happen in situations involving gross negligence.
Gross negligence.
Meaning, the work was so flawed, so reckless, it demonstrated a wanton or reckless disregard for the lives and safety of others, and it resulted in serious harm or death. Think major structural collapses, environmental disasters due to clear design flaws that were ignored or missed through negligent supervision. That can cross the line into criminal liability.
So legal liability is severe, but you also mentioned the ethical dimension. How does that differ?
It's broader. The codes of ethics demand integrity, honesty, and competence. Even if, luckily, no physical harm results from poorly supervised work, the act of approving something you haven't properly reviewed is still an ethical breach.
Because you weren't competent in that instance, or maybe not entirely honest about your oversight.
Both, potentially. You're claiming oversight you didn't perform. You're potentially allowing work outside your subordinate's competence to proceed. It undermines public trust and the profession's integrity. It's an ethical violation regardless of outcome.
Okay, so given all this risk, disciplinary, civil, criminal, ethical bar, how does a professional protect themselves, and by extension, the public? How do you prove you exercise that due diligence?
It comes down to having a deliberate, systematic, and crucially documented process. Due diligence isn't just a gut feeling that things are okay. It's about evidence.
What does that evidence look like? What are the practical steps?
The sources highlight a few key elements. First, communication and mentoring. You need to foster an environment where the people you supervise feel safe asking questions, raising concerns, discussing technical uncertainties.
Create that open dialogue.
Yes, and keep records of significant technical discussions, maybe in meeting minutes or project logs. That shows interaction.
Okay, communication. What else?
Second, the reviewing verification process itself needs to be robust and demonstrable. Simply initialing a drawing isn't enough. You need evidence of the review. This means things like detailed comments on drafts, calculation check sheets, marked up drawings showing what you verified, sign-offs, confirming specific code compliance checks were done. The documentation has to show what you checked and how.
That level of detail is vital, especially for anyone facing the NPPE.
Yeah.
You need to show your work, essentially.
You absolutely do. Third, documentation of delegation. Keep clear records of who is assigned what task, especially if it involves specialized work, and confirm they have the qualifications for it. This demonstrates you delegated responsibly within boundaries.
Which links back to the idea that blind trust isn't supervision.
Precisely. Blind trust is negligence waiting to happen.
Now, how does all this work in today's world? Remote teams, digital documents, collaborative platforms. Does that change the principles?
The fundamental principles, direct involvement, interaction, review, responsibility, they don't change at all. But the how, the logistics of maintaining control and demonstrating due diligence becomes even more critical.
So what's key in that digital context?
Well, that brings us to a fourth element, managing the digital environment. The professional absolutely must maintain sole control and security over their digital seal or signature. It cannot be shared or applied by anyone else.
Security is paramount.
And traceability. When you're working on shared platforms, you need systems that track revisions, show who made changes when, and record approvals clearly. If you're reviewing a digital design file, you must be certain you have the final, authoritative version that incorporates all checks.
So remote work actually demands more formal documentation, not less.
Arguably, yes. Because the informal, over-the-shoulder checks are harder, the documented trail of review and approval becomes even more essential to prove your direct involvement wasn't diluted by distance.
This really culminates in what must be a common ethical dilemma. You've got project deadlines, client pressure, maybe budget constraints, pushing against the time needed for thorough review and due diligence.
It's the classic conflict, efficiency versus safety, trust versus verification.
How do you navigate that?
The ethical mandate, according to all professional standards, is absolutely clear and non-negotiable. Public protection overrides everything else.
No exceptions.
No exceptions. If you are pressured by anyone for any reason to sign off, seal, or approve work that you have not had the chance to adequately review, verify, and understand, The only correct ethical and legal action is to refuse,
Refuse until the due diligence is done.
until you are personally satisfied that the work is sound and safe. Anything less is gambling with public safety and your own professional standing. So, to kind of synthesize all this, maybe the most powerful takeaway is that final declaration embodied by the seal. When you apply it, you are saying, without reservation, I stand behind this work.
Mm-hmm.
That acceptance of responsibility, especially for supervised work, isn't just a rule. It's the absolute core of professional integrity. It's why the public trusts engineers and geoscientists with decisions that affect their lives.
And thinking about it that way, supervision isn't just a burden or a risk management task. It's also how standards get passed on, right? It's mentoring. It's teaching the next generation about technical rigor and ethical responsibility.
That's a great way to frame it. It's a critical part of maintaining the quality and integrity of the profession over the long term.
Okay, so we've established that solid documentation is key. It protects the public. It protects you, the professional, especially now with remote work and digital tools being so common. So here's something to think about after we finish. In these complex, often digital collaborative projects, what single piece of documentation do you think is the most critical for proving adequate supervision, but might also be the one most often overlooked?
That's a good one to ponder.
Definitely food for thought. Thank you for joining us for this deep dive. If really understanding these legal and ethical frameworks for professional practice is important for your career, or especially if you're on the path to the NPPE,
This is bread and butter for the exam.
it really is. Please subscribe now so you don't miss future deep dives. We aim to give you the insights you need to succeed on the NPPE exam and in your practice.